This is part four of the essential nature of the offense. Um, so, we were talking about conversion, and I know I've gone off on some pretty far out topics, and you're wondering how in the heck is this related to my case? Okay. So, um, when somebody initiates a malicious prosecution or a vexatious litigation, they are essentially converting the courts and law enforcement, anything that might be used in those cases, to do something to you. Uh, they are converting the courts into their own private property. And the moment that you can show that somebody has done that, then you can accuse them of unlawful conversion, okay, or misappropriation if they're a public official, or say you've got an attorney who has basically initiated and conducted a malicious prosecution, vexatious litigation. They've created court orders based upon fraud, perjury, deprivations of due process. They have essentially created a condition where all of the proceedings are invalid and the orders that come from those proceedings are void. And I would highly recommend that y'all get online and do some research on what void orders are and what that implies. Okay, void orders are void from their beginning, and they do not require the acknowledgement of a court to be void. Okay, I think it was Shuttlesworth versus Birmingham where they said that where a protected right is licensed or permitted unconstitutionally, that the license or permit may be ignored and the right can be exercised with impunity. I have one case where a father initiated a malicious prosecution against a mother. There was never any evidence to show any unfitness on her behalf. He had no cause and standing to initiate the prosecution to begin with, or the litigation. And long story short, the mother had evidence that he was abusing the kids. He was a cop, and every time she tried to report it, nobody would ever give her reports due process. Nobody would afford her and her children crime victims' rights and equal protection. And when she finally received evidence that she had reason to believe that he was drinking and driving with the kid in the car, that he was, in fact, physically abusing the kid, he was making statements about it in record, was talking to one of his friends about it. And so, like any reasonable, responsible parent would do, she went and rescued her child. Okay, now, when the child was rescued, her mother was sick and dying in the hospital in another state, and it was an emergency. So it was kind of a two-part deal where she was acting in defense of her child. She could support her claims with evidence. She reported it. The cops would not give her due process because he was a cop. And she took her child out of state. She actually told them what was going on. Said, look, my mother is sick and dying. I got to go out of state. I got to, take care of her. I'm going to move her back to Texas, and I'm going to take care of her for the rest of her life. Well, while they were out there, the mother fell deathly ill and ended up dying of COVID. She was a cancer patient. And so the mother, was kind of in a pickle where, she had to stay there out of state, close out her mother's estate. So she had to go through all that process. The family came down for the funeral and they had their wake. Well, now, during this time, and despite the fact that the mother had given notice to the other party, his attorney went and file an enforcement action. And the next thing you know, there are federal marshals hunting her down as a fugitive from justice. And what that attorney did is conversion. She converted law enforcement and the court into her own personal property to then, libel the mother and gang stalk her, falsely arrest her, falsely imprison her, and unlawfully take her child into custody and kidnap that child under color of law. Okay? She ended up sitting in jail for 5 days. Okay? She had everything she needed to show that she had every right and reason to rescue her child from the father. Okay? So this is just an example of how corrupt attorneys and corrupt litigants will convert the courts into instruments of crime. And in your cases, and I know you would not be watching this video right now if you did not have reason to believe that, there is a crime being committed in the courts against you or somebody you know or somebody you love. So, this is one of the reasons, the primary reason that I'm telling everyone, go read The Art of War, get on YouTube, search up The Art of War, and listen to it. Because the first thing that you must do is you must convert your thinking from being a victim on the defense to being a hunter on the offense. If you do not do that, you will be at their mercy forever. Okay? I know another lady, 2 ladies actually. They were wealthy people, and they've both got corrupt attorneys coming after them, and they're just filing malicious, vexatious, and frivolous suits against them over and over and over, and all they're doing is draining them of their money. One of these ladies has spent over $400,000 as a result of malicious prosecution and conversion. Okay? So, and I know all of y'all are probably sitting there thinking, so what do I do? What do I do? What do I do? Well, I tell everybody, the very first thing you've got to do is you've got to make a timeline of events, just like they taught you in 2nd and 3rd grade. What I suggest folks do is, get you a Gmail account and get Chrome on your laptop. Don't try to do this on your phones because it's too hard. It's just too slow to work with documents and things on phones. You need to get an actual laptop or a desktop, get Google Chrome, get you a Gmail account, and download Google Drive onto your computer, okay? And create you a folder in your Google Drive called My Case or something like that. And open that folder and then click the little plus button and click Google Sheet, and it's the little green icon. And Google Sheets is a very simple, easy to use spreadsheet program. And what you're going to do is you're going to go back in time, think back in time to the first significant event that happened, okay? Somebody called somebody and made a report, or somebody filed a complaint, okay, in a court, or maybe with CPS or something like that, or maybe it's the police, okay? That's the first column, is the first significant event. And then what you're going to do is think to yourself, and I know most of y'all probably have a mountain of paperwork sitting in front of you. It's a big spaghetti bowl mess. You don't know how to begin making sense out of it all. What we're going to do is we're going to let the calendar organize everything for you, okay? If you look at that big pile of paperwork and you're like, man, there is no way I'm going to be able to start going through this paperwork and get it all organized, okay? Right now, at the very beginning, we just want to rely on your memory first, okay? We'll look at the paperwork later on, all right? But right now, the most important thing is that you make a calendar of events, a timeline of events. So, just go down the line in the first row, in the first column, put a date, okay? And then the second row, write a note. This is what happened on that date, okay? Now, if, let's say that on the first date, the first significant event, okay, let's use a domestic incident as the example. Okay, so in the first column, I was dating this person, we broke up, and we were arguing. Okay, that's the first one. All right, short and simple. All right, and the second one, on this date, this person came to my house and came into my house uninvited. And then you put a note to yourself under that, breaking and entering. Okay, they came in uninvited. Okay, now let's say that they came in the house and they started breaking stuff. Okay, on that same date, that person, having unlawfully entered my house, committed vandalism and destroyed this, and this. Okay, and you put a little note to yourself: malicious mischief, vandalism. And you go to the next one. You say, on this date, this person had unlawfully entered my house. I called the police and I reported this person for this offense. And this officer neglected to perform his duty, where he refused to take my report, refused to give me a report number. Okay? And you make a little note to yourself: neglect of duty. Okay? Official oppression, deprivations of rights under color of law. Rescue and escape. That's where an officer allows an arrested person to escape their custody. Okay? So then you'll go to the next one. On this date, I went to police chief whoever, and I reported his officer Smith for neglect of duty. Okay, and rescue and escape. And police chief whatever neglected to prevent the crime, neglected to intervene. Okay, these are violations of 18 U.S.C. Section 242 or your official oppression statute in your state. Okay, because under 242, if you go look in the Department of Justice Criminal Resource Manual and you search for, like, go to Google, search for DOJ, CRM, official misconduct, failure to intervene. And you will find in the Justice Manual and the Criminal Resource Manual where it says specifically that where a superior officer witnesses or receives evidence that one of their inferior officers has deprived a protected right, that superior officer then has the duty to intervene and prevent him from doing so. This is why in, I don't remember if it was the George Floyd case, but essentially one cop was killing another man unlawfully, and 2 or 3 other cops were standing there, and they did not intervene. And they ended up getting indicted for it as accessories during the fact because they did not intervene. All right. So the same applies even in the most simple cases. Anytime a cop is depriving someone's rights, okay, let's say that you're on the side of the road and, 2 cops arrive, okay, and one cop asks you, may I search your car? You say no, and he says, well, I'm going to do it anyway. And the other cop does not intervene and say, hey, buddy, you cannot search their car because they declined. Now, if you're going to ticket them or take them to jail, then that's what you need to do. But you cannot simply deprive their rights because you decided to. Okay? I think I said this a little earlier, that Any official who deems themselves to have jurisdiction where they have none does so in a private capacity at his own peril. Okay? He is not operating as a police officer at that point. If you're standing in court and a judge, you present them with evidence. You want to make arguments to defend your case. And they say, well, I'm not going to hear that. Or they'll say, oh, well, we'll take care of that later. And they never get around to it. Okay? That is official oppression. That is 18 U.S.C. Section 242. Okay? So, and that's a deprivation of due process. It is an official crime. And the bailiff who is standing there in the courtroom, he's a peace officer. He has the duty to intervene at that point and say, Your Honor, you have to give these people due process. Okay? You have to take those exhibits into record, and you must decide. That is your job. Okay? Now, 9 times out of 10, when a judge does not want to address a matter, it is because he does not want to give you due process. It is because he does not want you to defend your rights. It is usually because he is biased for one of the parties. Okay? This week alone, I have found 4 cases where the malicious litigant is a former domestic partner of the targeted parent, and that malicious litigant is a peace officer, a police officer, a deputy, or maybe they were a former deputy, or maybe they were a family member of a deputy or another, public official. Okay? Abuse of official capacity is where you have people who have some kind of relation to public offices, usually law enforcement or the judiciary, and they seize upon their professional relationships. Like maybe you've got a bailiff, or maybe you've got a street cop that's been in one jurisdiction for 10, 15 years. He knows all the judges. He knows all the public attorneys. He knows all the jailers. He knows everybody. And suddenly he decides that he's going to target, baby mama, for example. Okay? So the first thing he does, he goes and he files a false report with one of his buddies. Hey, buddy, I need you to do something for me. Okay? I got one case where that's exactly what he did. He was a cop. He targeted his baby mama. And he went to his own police department and tried to file a false missing child report to initiate a gang stalking under color of law and a false arrest against her. And his own police department told him, no, you can't do that. You know that the child is with the mother. Unless you can show us some evidence that the child is actually in danger, we can't do anything, and you shouldn't even be trying. So what did he do? He went over to the sheriff's department where one of his best old buddies works. And he talked to him in private and said, hey, this is what I got going on, and this is what I want you to do for me. Okay? I want you to take this missing child report, this false missing child report, and I want you to make a report, and I want you to initiate everything and get it rolling. I want you to convert law enforcement and missing child services and features like the Amber Alert system to hunt this woman down. And he did. And they arrested her and took her child from her. She did not hear from her child for over 4 months, not so much as a word. And that was under orders from a judge whose proceedings had already been proven invalid. All of the orders from that judge's court are void. This is why I'm telling you, you need to go do some research on what are void orders. Void orders are void from the beginning. They are not voidable. Okay? You cannot appeal void orders. You cannot modify void orders. You cannot do anything to a void order. A void order does not exist. It is a void. It is empty. It's just nothing there. Okay? And when you go into your cases and you go into your courts and you can show that there was fraud perjury, crimes committed within the court, deprivations of due process, those orders are void, regardless of what that judge says. And no judge who sets up void orders is ever going to admit to it. You don't go into that judge and say, Mr. Judge, these orders are void, and I need you to agree to it and vacate them. That's not how it works. Okay? You're going to have to go to, let's say you've got a corrupt judge. Okay? He's depriving you due process. He's willfully blind to evidence in your favor. He's not allowing you truth and record. He's depriving you due process. I mean, he's doing everything he can to be biased and steer the outcome of these proceedings in the favor of the other party. Then what you'll do is you'll get the copies of the transcripts, you'll get the copies of everything, and you'll go through them. Every single time you find an example of him or anybody else in that court having violated a code or deprived a right, that's another column entry in your timeline of events. And you convert each of these column entries into a separate criminal information. Okay? And then what you do, because most of the family courts and most of the traffic courts, there's a magistrate there. He is the judge hearing the matter. You've given him notice. Okay? You can tell him, notice, you can file a motion, notice to vacate void orders, even though we know that you can't vacate void orders, even though we know that he's not going to do it. But in your motion to vacate void orders, you include the criminal information to show him, look, buddy, these are the criminal codes you have violated. Your only alternative at this point is to restore everything back to the way it was. I am not motioning for you to do that. I am giving you notice that this is your duty to do this. Okay? And where you can show that the other attorney has committed aggravated perjury, and you've got evidence to support the claim. You show the exhibit where they lied. You show an exhibit to show that what they said was a lie. And then you lay a criminal information in front of that judge, and you tell him, sir, you're a magistrate. I have just given you irrefutable evidence that attorney has committed aggravated perjury. You have a duty to issue a warrant for their arrest. Now, do I need to arrest them out of this court right now, or are you going to do it? Because if I do it, I'm going to release them into your custody. Okay? And then if you let them escape, now you're going down for rescue and escape, and that's a felony. Okay? So everybody needs to look up arrest without warrant. Okay? Now, most of the statutes say that a citizen's arrest, an arrest without warrant. So not only do police officers, peace officers, and magistrates, not only do they have the right to conduct warrantless arrests, so too do the citizenry for any breach of the peace. Now, most of the statutes in most states say it's got to be a felony, and that's not true. I've looked up the case law. Okay? Does not have to be a felony. It could be something as simple as jaywalking. Any breach of the peace within view is an arrestable offense by anyone. I have one fella in the state of Virginia who had some colorable crimes committed against him. He put the party on notice and gave them an opportunity to retract. Told them, what laws they were in, what criminal codes they were in violation of. He put them he put them on notice, gave them an opportunity to retract. They refused. And so he placed them under arrest for a breach of the peace within his view. And then he went and called the sheriff. Well, it just so turns out that the person he had placed on notice and placed under arrest was a good friend of the sheriff's deputies. 3 deputies showed up, and not only did they fail to investigate his claims, take his evidence into record, and take the prisoner into custody, they turned around and falsely accused him of impersonating a police officer. They assaulted him. They kidnapped him from the scene. They falsely imprisoned him. And then they initiated a malicious prosecution against him in a conspiracy, an attempt to falsely imprison him for a long time for impersonating a police officer. He never claimed to be a peace officer, not to one single soul. And he got assigned a defense attorney, a public defense attorney. And it's like I said before, the better defense is a better offense. Just like we are subject to the failure to report and misprison of felony statutes and have a duty to report crimes, so do the defense attorneys, so does every attorney in this country. Okay? So what he did is he wrote up his timeline of events and his criminal information. And he sent the criminal information with an unsworn declaration under penalty of perjury. Now, here's the thing. Look it up. U.S. Code, unsworn declaration under penalty of perjury. And that is where a party makes a declaration that is binding, and it cannot be ignored. Okay? Because you're saying, I, Joe Blow, declare under penalty of perjury the foregoing is true, executed this day, and you sign it. Okay? You sign it and date it. And basically, that's like being sworn in. Because you are declaring to the world, if I'm lying, I'm dying, and you can put me in jail if I am. Okay? And no court, no police officer, no attorney may ignore that. It is a binding official document at that point. Okay? It does not have to be notarized. It does not have to be witnessed. It helps if it is. Okay? But it does not have to be. When you sign your name on that dotted line and you make that statement, you're bound to it. And so are they. So let's say that you've had a conspiracy to commit kidnap under color of law, a conspiracy to commit racketeering and take your money under color of law through these family and traffic courts and civil courts, okay? And, you're like, well, I know that there are crimes having been committed. I made out my timeline. I identified the unlawful activity. I correlated it to a statute and the colorable offenses, statutes, deprivation of rights under color of law, official oppression, abuse of official capacity. I have made a proper criminal information with supporting evidence. So now what he did is he went and he sent that criminal information to his attorney, and he instructed the attorney. He gave the attorney notice. This is what you are to do. You are to file this criminal information into the case files to show that these people are committing crimes under color of law. And that is my defense. Okay? And then what he did is he sent the same criminal information with his declaration under penalty of perjury and told the prosecutor, sir, with all due respect, I presume you are an innocent party. However, you have been unlawfully compelled to unwittingly participate in a conspiracy to retaliate against a victim, witness, or informant, and you have initiated a malicious prosecution. And I am writing you to allow you to investigate and see that you have the duty to dismiss this case, or notify the magistrate of what I have given you notice of, and you are to make sure that this criminal information gets a report number and that these criminal reports are given due process. So what he did is he flipped the script on these people. They filed a malicious prosecution or a vexatious litigation against him, and they put him on the defense. So he immediately went on the offense. He can prove what he's saying with evidence and law. They can't. Okay? And they know it. And so does the prosecutor. Okay? Now, the defense attorney told him, well, I'm not going to turn this in. I'm not going to do this. And so we wrote up a criminal information against her and we sent it to her. The next thing you know, she's on the phone with that prosecutor and the case is dismissed. Okay? Now, the next thing they should have done is they should have prosecuted those people, those 3 deputies. Okay? But they didn't do that. And at this point, He was, just glad to be out of jail, glad to be free. Okay. And he walked away. And I told him, I says, if you walk away now and you don't follow through, this is not over. They're going to come back at you. It's just a matter of time. Okay. Sure enough, they did. He received 3 credible death threats on social media from those people. And after arguing with me long and hard, I eventually talked him into writing up the criminal information and going to a magistrate. And he converted a corrupt Blue Wall of Silence police officer into a fugitive from justice, because that judge looked at the evidence and he issued a warrant. The man left town. And he was on the run for, I think, about 2 months. And then he finally turned himself in, paid the fine, and he walked away free, turned right around and threatened this guy again. So I told him, you need to take that and go back to the magistrate. Well, he didn't want to do that. So now he is still to this day, he is being stalked and harassed by local cops. And he's not getting justice in his case. And these people are free to keep doing whatever crooked shit they're doing in that county. Okay? And I know everybody just wants their life back. They just want to have their kids back. They just want their money back. They just want to get on with their lives. Okay? Like I said earlier on, constitutionalism is not about defending your rights. It is about defending the rights of others mutually. Just like every one of you is looking for somebody who will come out of the woodwork to help you and defend your rights. Guess what? You got to do the same for others. Because if you don't, well, that's how we lose it. Every single one of you who has been targeted and had these crimes committed against you, it was because, and make no mistake, it was because previous victims of these people did not pursue them. You must pursue them like a starving wolf. You will never stop. You have no choice. Because you know that if you do not go after that corrupt attorney, if you do not go after those corrupt cops, if you do not go after those corrupt judges, if you do not go after those malicious litigants, it's just a matter of time before they do this same thing to what they did to you. You've got to get serious about